Good morning, everyone. We'll get started now. My name is Matthew Cherry, TABC Senior Counsel. And so today's meeting or public hearing, what we're going to go over are the rules that were proposed at last month's commission meeting. And these proposals were also published in the November 29th edition of the Texas Register. So today's your opportunity to provide any oral comments. The agency is still accepting written comments, and those may be provided all the way through December 29th. So I'll get started with the first item that we have up, and that is some amendments to chapter 33. First one is 33.2, and all this does is remove some unnecessary text relating to the physical paper applications to better align with our process now that we have in the AIM system. Next is 33.23. And what we've done here is remove the 2-day minimum for a nonprofit entity temporary event authorization, and that aligns with current practice. The licensing division has been issuing those NETI authorizations just for 1 day. Next is 33.44. So all we've done here is amended subsection B to cite the appropriate rule for excise tax bond amounts. So those were previously in Rule 41.42, and now it's been moved to 41.39. Next is 33.45. All we've done here is make some conforming changes to remove any references to the old brewer's permit that existed in chapter 12. And then next is 33.57. So this refers to application withdrawal and the procedures and process following that. All we've done here is amend business days and change calendar days to, I'm sorry, we've amended and taken out business days and changed that to calendar days to account for the AIM system and the fact that it's a 24-hour system. Next is 33.75. And what we've done here is just amended subsection C to cite the appropriate rule for place or manner violations. 35.31 has now been moved to 34.3. Next is 33.93. So this is just a conforming change to align with the proposed amendment to Rule 50.24, which we'll go over in our last item today. And then we also have amended 33.100. This just added some language to subsections A and B to better track the statutory text, as well as deleted subsection C. It's now deemed unnecessary because of the amendments that we've made in 33.105. Next is 33.101. We've deleted this rule now because the contents of the rule is now going to be covered by 33.100 subsection B with these proposed amendments. Next is 33.102. We have no changes to that one. And then 33.103, we've added language again to track the statutory text and to make it clear that it is the ALJ that issues that final decision and it's not the commission. Next is 33.104. This is a non-substantive change. We just changed order to suspension to make it clear that the term of the suspension is actually going to be stated in that order. And then lastly, we have proposed repealing 33.105 because again, that information is now covered in the other rules with these proposed changes. And that actually covers chapter 33, so our first item for today. So now I will open up the floor to take any comments. Not hearing any, so I'm going to move on to our next item. And that is going to be proposed amendments to chapter 45. So first up here is 45.9. What we've done here is propose some amendments to mirror the application withdrawal rule for licenses and permit applications and also apply that to product registration applications. And then 45.11. We've just made some minor changes here. They're non-substantive. And what we've done is remove the word federal before it appears before the word COLA, because COLA is already defined in the definition section in chapter 45. And then 45.12, same type of conforming changes as 45.11. And then we also have 45.20. So what this does is just changes that reference to a COLA to the product registration certificate, just to align with the language that's currently used in the rest of the rules in chapter 45. And then we also have proposed amendments to rules 45.30, 45.40, and 45.50. These are all the same types of conforming changes, just to better state the current process and requirements for product registration for each classification of alcoholic beverages. And then lastly, we have 45.105. So these are some changes to the advertising sections. So first up is subsection A. These are non-substantive changes as well to the types of advertising that is already authorized. And then currently subsection A refers to a restriction on outdoor advertising on retailers' premises and requires an inference to be made that the outdoor advertising is authorized. So we've added this new subsection A2 to clarify and make it clear that outdoor advertising is permissible, and included references to both billboards and electric signs as those are authorized as well under the code. We've also added subsection A5 to reiterate and reflect the code's prohibitions on forms of inducements that you'll find in Rule 45.110, and specifically payments for particular placement of advertising. And then we've also added a new subsection A6. This relates to subsection A5's prohibition and acknowledges the currently permissible avenues for upper tier members to provide certain types of signage to retailers. So that authorization does not appear to conflict with subsection A5 for the signs that are sold under 45.113 and or 45.117. So they don't equate to a prohibited payment for ad placement. And that covers 45.105 and all of chapter 45 for these proposed amendments. So I will now open up the floor to take any questions and any comments.
Matthew, Marcus Schwartz, can you hear me?
Yes.
Good morning to you, sir. One question specifically related to 4520, and I will preface this by saying this is not directed to the current comments, but while we're potentially reviewing this rule, I was curious as to the interplay between, handing over a COLA with record-keeping timing requirements. And for a real-world example, I had a client that was recently audited, and they went back 5 years on the audit, and they asked for product registration and COLAs for a product they made 5 years ago, but stopped making 4 years ago. And these COLAs, are good indefinitely. And so I just don't know exactly how that works when permittee is no longer required under your record-keeping requirements to have that COLA for a product that is gone, so to speak, right?
Okay. So are you asking about, I guess, our requirements to retain a copy of the COLA, or was...
Yes, and do those extend beyond via 4520, the standard 2 years you have to keep records, especially for a product that's not in the market anymore? It hasn't been for, well over 2 years.
Okay. I'd have to go look at some of our other rule sections. I think that type of question right now is just kind of beyond the scope of this public hearing. But if you want to give me a call later today or something, we can definitely interface and kind of have a discussion about those types of requirements.
Appreciate it.
Absolutely. Any other comments on chapter 45? I'm not hearing any, so I'm going to move on to our third item, and that is just a proposed amendment to Rule 50.24. And so what we've done here is take some of this language that was already in chapter 33 for actual license and permit applications, and that did reference the seller school certificate holders. And so we've moved this information over there. And all this does is clearly state the requirement that those seller server schools must maintain a current mailing address, telephone number, and email address on file with our seller server training division. And then if there are any changes to any of those three forms of communicating, then the holder shall file those changes with the commission within 7 business days of the change. And that is the only proposed rule we have for chapter 50. So now I'll open the floor to any comments on the proposed amendments to Rule 50.24. I am not seeing anything. Now I'll open it up in case anyone has any comments they want to make on chapters 33 and 45 as well. Okay. All right, well, I will remind everyone, this is not your only opportunity to comment on these proposed amendments to the rules. The formal comment period to provide written comments is still open through close of business on December 29th. And thank you for your time today, and have a great holiday, everyone.